Welcome back, friends, to another session of IBC 2016. In our last discussion, we had discussed about the provisions of resolution plan, the resolution applicant submitting the resolution plan, and the process of accepting the resolution plan. And in our last lecture, I had discussed that once the resolution plan is accepted, that will bring an end to the whole process of IBC, friends. So, taking it further, and as mentioned in my last lecture, that in my next lecture we'll be covering the various timelines to have an overall view, and by this understanding, yes, how the IBCs has worked, and whatever we have discussed, that has to be within a time frame, and how these time frames actually cover the whole process, starting from section number 14 for the applicability of the moratorium period till section number 30, where the resolution plan is accepted by the A. All these things have to be carried down within a period of 180 days, and that we'll discuss in a timeline sheet, friends. But before that, I think very important section which was introduced in 2000 in the initial phases of IBC, where there were certain restrictions which were put into the person who can apply for the acquisition of the corporate debtor as a resolution applicant. And that was a very important section which was introduced, which barred a lot of people to apply for the company. And I think we need to understand this section, which was a point of dispute at various points at the NCLT and other court of law. But yes, now things are very clear, and it has been clearly mentioned that who can apply for the resolution, who can be as a resolution applicant. So a person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert with such person. We all understand that when you have to be a resolution applicant for a company of big nature, probably we have to apply in a joint, acting jointly or in concert. So if that person is an undischarged insolvent, then he cannot apply. Is a willful defaulter, and from time to time the RBI issues a list of all the willful defaulters who have defaulted in repaying the loan. So in that case, is not eligible to apply. Then as an account or an account of corporate debtor under the management or control of such person, or of whom such person is a promoter classified as a non-performing asset by the RBI, and at least a period of 1 year has lapsed from the date of such classification. So very important. So if any account has been classified as an NPA by RBI because of whatever reason, then such person is not allowed to participate as a resolution applicant, provided is one of the promoters of this particular non-performing asset. Then provided that such a person shall be eligible to submit a resolution plan if that person totally pays all the overdue and the with interest and the charges relating to the NPF. So that is very logical. That should be there. So a willful defaulter, NPA account, there should not be allowed. Then has been convicted of any offence punishable with imprisonment for 2 years, is disqualified to act as a director under the Companies Act, is prohibited by SEBI from accessing the securities market. So these are normal restrictions which should be there, very logical. And then very important, friends, has been a promoter or in the management or control of a corporate debtor in which a preferential transaction, undervalued transaction, extortionate, exited transaction, or fraudulent transaction has taken place, in respect of which an order has been made by the adjudicating authority under this code. So with respect to certain sections of 43, 45, 46, 65, 66, if the order has been issued by adjudicating authority, probably that particular promoter or a corporate debtor is also not eligible to perform as a role of a resolution applicant. So these are certain restrictions which have been placed under section 29A, and I think the major part is with the section point number 2 and point number 3. I think that has restricted a lot of people to participate in the process of submitting a resolution plan, friends. And probably this puts a lot of constraint on bringing out a resolution for a particular company. But yes, this was necessary also to ensure that the process is very transparent. And then the last point, probably any company has executed an enforceable guarantee in favor of a creditor in respect of a corporate debtor, then against which an application for insolvency resolution has been made by such creditor and has been admitted under this code, probably in that case also is not allowed. That means that if he has issued a guarantee in favor of a creditor who has been brought into a insolvency process, then probably then also it is not that person is not allowed to participate in the resolution process. So taking in view of this consideration, I think there are few people who will be now left out of this whole process, and maybe this will again enforce that the objective of the law is achieved, and that is why this section has been introduced. Okay, so that was section 29A, and if you further understand and if you go for further detailing of the section, we'll understand that there are three layers of ineligibility in understanding this section. The first is the person acting in concert. So person who having the common objective, purpose of acquisition of shares, voting rights, exercising control over company pursuant to an agreement, probably they will be referred to as a person acting in concert. So that is the first layer, they are being removed. Then the connected persons, very important friends, any person who is the promoter or in management or control of the resolution applicant, then any person who shall be the promoter or in management or control of the business of the corporate debtor during the implementation of the resolution plan, or any holding company, subsidiary company, associate company, or related party of the person referred in above. So probably that second layer is also removed. So in a way, what they are trying to restrict is that anybody who is related to this particular corporate debtor, connected to this corporate debtor, probably he should not be allowed to submit the resolution plan. And obviously a direct one where any related party, anyone in relation to the individual, defaulting promoter, or their spouse, partner in a partnership firm or a trust in which the defaulter individual is associated, a private company in which this individual is a director and holds more than 2% of the share capital, including family and relatives. So it is a very broad base, I think. And if you practically understand, probably when a resolution applicant submits a particular proposal, then he has to give an affidavit declaration regarding 29A that he is not falling under the section 29A and therefore is eligible to submit the resolution plan. So very broad-based coverage, and probably a due diligence has to be carried out by the RP also to find out, yes, whether that particular resolution applicant falls under any of the criteria of a 29A, friends. So a lot of homework has to be done by the RP before ensuring that, yes, 29A is being followed or not, friends. So now we have covered all the parts of the process of CIRP, friends, till the resolution plan is accepted. Let us go through the timelines, and then you will understand, yes, how these timelines are being taken care by the resolution applicant, the resolution professional over a period of time over these sections from 14 to 30. Yes, for a case study regarding 29A, I think the major case study you can obviously refer is the JP Infotech case study, which has again very clearly laid down that what is the objective of 29A, and therefore any promoter of such nature is disqualified to apply as a resolution applicant. Okay, so timeline, let us understand these timelines, and we'll present it in a chart form. Very important, friends, this timeline where it starts from, let's say, T. The T word is the commencement date of the CIRP and the appointment of the IRP, and we have seen under section 16, the IRP is appointed, friends. And then accordingly, the regulations and the sections will work in tandem. The first step, as we understood, that a public announcement has to be done. So the public announcement will be done within 3 days of the appointment of IRP, which we have already discussed. So the timeline starts from T plus 3. Now, section 15 and the regulations of 6.2 and 12.1 says that you have to call for the claims, and the claims will be submitted from the 14 days of the appointment of the IRP. So within 14 days, we'll receive the claim. But yes, as we said, as we have discussed again, is that the claims can be received till the period of 90 days also. So T plus 90 is the maximum time period where we can receive the claims. Now remember, once the claim is received, the job is not over. We have to verify the claims. So if we receive it within 14 days, a period of 7 days is given from the receipt of the claim. So assuming that 14 days and 90 days. So T plus 21, if we assume it is received within 14 days as announced in the public announcement. So T plus 21, where we have to verify the claims, or T plus 97, as the case may be, where the verification of the claim has to be done, friends. So that is the initial timeline, but within these 97 days, like a lot of activity has to be done, friends. So the other activity which we need to ensure that is being done within the timeline is application for appointment of AR, and we have discussed AR. AR is nothing but an authorized representative, a representative who is representing a particular class of creditors. So it may be a group of financial creditors appointing one person, or the home buyers in case of real estate projects appointing one person to represent them on behalf of them at the COC. So that has to be done within T plus 23. That is within 23 days of the starting of the CIRP period. Now, which in fact means within 2 days from the verification of claims received under Regulation 21. And then accordingly, there's another job which we have to do is to report certifying constitution of COC. That is to be submitted to the adjudicating authority, where we will see, put down an application saying that yes, this is the COC which has been formed after verifying on the claims. Then, as we all know, that the first meeting of the COC has to be done within 30 days. So within T plus 30, the first COC meeting will be done, which in fact means that once the COC is being constituted, within 7 days, we have to call this particular COC meeting. So T plus 23 plus 7, which will make T plus 30 days. I think all these sections we have covered. Section 22 along read with Regulation 19. Now, as we all know that yes, the IRP can be appointed as RP, or we have to appoint a new RP, that is as per Section 22. So in the first COC meeting, that particular action is taken by the COC, and either the IRP continues or the new RP is appointed. And once the new RP is appointed on the approval of A, though there is no such time limit, but yes, because there are further processes which has to be carried on, so there must be certain time limit which is there, which is not there. So there's a gap. And then if let's say the RP is not appointed within a time frame, from the 40th day, the IRP will take over the role of RP friends from the 40th day. And then what does the RP has to do? As we have understood, we have to appoint a valuer. That is the first job the RP has to do. That is within the 7 days of his appointment. That means by 40th day, we'll assume that the RP is appointed. So within 7 days, that means by the 47th day, the RP will get appointed. Now, that is one part which gets completed. And in my previous session, we had discussed and the timeline for the resolution plan also. So let us start with the process of resolution plan, which starts with the process of issuing an EOI. But yes, what can happen in between? Before we proceed ahead, there may be cases where there may be situation where the case is withdrawn also. The applicant who has filed an application and in the NCLT for filing a case against this corporate debtor. So the applicant may now again come back to the NCLT and say that I want to withdraw my case. So that is the problem. And that we'll discuss we'll have a separate session for what are the situations where the cases can be withdrawn. And that is a very important, relevant points which we have to understand in terms of understanding the law as well as the professional opportunity. So that can happen separately. That is covered in the Section 12A. So those timelines are denoted by W, that is the withdrawal part, and probably we'll touch it later, friends. Now, going ahead, understanding the role of the RP is that he has to form an opinion on preferential transactions, which again we are going to discuss in our next topic when we'll cover the liquidation part, and that has to be done within 57 days of the commencement or within T plus 75 days of the whole process. So these are the two timelines. Normally, the 75th day is taken where he has to form an opinion, right? He's not required to submit any report, but he has to create an opinion. And then once an opinion is formed, he has to submit it to the COC first. And also he has to make a determination on preferential transactions, if any. Again, that is to be discussed again in one of the lectures. And again, during liquidation, we'll discuss this point. And that has to be done within 115 days. And then for both the things, he has to file the applications within 135 days for any appropriate relief if the RP demands, right? So that is a separate angle where we have to take care of all the preferential transactions and other type of transactions, and he has to report it to the adjudicating authority. Now, coming specifically for the resolution plan, friends, now once the valuer is appointed, the whole process shifts to the calling for the resolution plan. Therefore, the first step, as we have discussed, that he has to prepare an information memorandum, that he has to submit it to the AOC, and that will be done within the T plus 54 days or 2 weeks after the RP is appointed. So within T plus 54, because RP will be appointed by 40th day. So by the 54th day, that process will start, and therefore the IM will be submitted to the COC on the 54th day. Then it comes the Form G part, friends. The Form G has to be submitted. Form G is nothing but a document which will be submitted on the paper to invite resolution the resolution plan from all the resolution applicant, and therefore it has to be done by the 75th day, that is very important, friends, that is to be done by 75th day, which is missing out here. And that Form G has got a specified format, as same as the public announcement. That is, public announcement was Form A, here it's Form G, where they will define the timelines, that by what timelines they have to submit the resolution plan. And so in that Form G, there will be an invitation for expression of interest, EOI, and that expression of interest is basically giving invitation to all the prospective resolution applicants. So once that EOI is released or Form G is published, then the submission of EOI, that means within 15 days, people will submit the expression of interest. People who are interested, they'll submit it within 15 days. Yes, that we are interested in this particular corporate debtor. And then the provisional list of resolution applicant by the RP will be released within next 10 days. Plus 100, 90 days plus 10, then 3 plus 100 from the receipt of the EOI. So he will submit that list to all the COC members, that these are the prospective resolution applicant who will be interested in bidding or submitting their resolution plan. And then submission of the objections of provisional objections to the provisional list. So if any COC member has an objection to that particular list, they can raise it, and that is to be done within 5 days. So that will take the total number of days to 105. So the process is very, very crisp and very fast, friends, right? It's an action-packed thriller which will happen within 180 days, and we have to comply with all the timelines, because each step is, will be succeeded by another step or preceded by another step. So they need to ensure that it is done within that particular time frame. Obviously, practically, if you see, there are certain gaps, because a lot of things are pending at the NCLT, and therefore there can be certain delay in all these timelines. But yes, if everything goes as per the law, probably it has to be followed in as per the timelines given in the bylaws. So then we have the final list of RAs by the RP. Once the provisional list is approved, then we have the final list, where within 10 days of the receipt of the objection, the RP will submit the final list of the prospective resolution applicant, right? So 115 days are gone. So what will happen after that? Along with that, to the prospective resolution applicant, how will they submit the plan? Because so that means we have to give certain information to the prospective resolution applicant, that is issue of RFRP, request for resolution plan. So we'll issue a particular request asking them to submit a resolution plan, which will contain a list of whole lot of detailed information what is required from the resolution applicant, including the evaluation matrix EM, which we have already discussed, and including the information memorandum, which we have already discussed. That will be done within 5 days of the issue of the provisional list. Then within 30 days, the resolution applicant has to submit the resolution plan, because he will also require to understand from the RFRP what is required to be submitted, and then based on that information memorandum, he will submit a resolution plan, and that is to be done within 30 days. And then once the plan is submitted, then within next 30 days, the COST has to meet, negotiate with the resolution applicant, and get the revised resolution plan. And if there are more than one or resolution applicant, then they can sit and negotiate who can give a better deal. And then finally we come to a particular final resolution applicant, and once that particular plan is approved by the COC, it will be submitted to the adjudicating authority as soon as it is approved by the COC, and that should happen by 165th day, so that even the adjudicating authority takes about 15 days to give the approval to the plan, subject to whatever conditions they may allow, friends. So that means by 180 day, the whole process has to come to an end, friends. So these are model timelines which has been given as per the IBC code, and we as a RP, we all have to follow these guidelines and the timelines from time to time, and that's why I say it is an action-packed story, friends, for the next 180 days. So from this, we have understood that we have covered all the aspects of these timelines, from the appointment till the submission of the plan to the A. And I think now we have a broad picture understanding of the whole process of the insolvency, friends. So is this the end? No, friends, I think this is not the end. There are a lot many things to come. So picture abhi baki hai those, and we'll discuss those relevant points in our next lecture, friends. Till then, thank you and see you soon, friends.